Today's program, Hatfields versus McCoys, Common Myths About Neighbor-to-Neighbor Disputes, is being presented by Deborah Warren, PCAM of Associa, and Stephen Weil of Birding and Weil. In the interest of time, we have a short bio for each speaker. If you'd like additional speaker information, please reach out to Kelvin Nanny at the registration desk. Steve Weil is the principal of Birding and Weil LLP, a law firm of over 30 attorneys serving community associations with offices in the San Francisco Bay Area and Orange County. Deborah Warren is the vice president of development for Associa. Since joining the Associa family in 2012, she has held positions on the operations team supervising branches on the West Coast and Canada, as well as contributing in the area of client relations and community manager education. Take it away.
Thank you very much, Emily. And it's great. It's great to be here in the North Bay, home for me. And it's great to see so many familiar faces this morning. For those of you that have come from all around the Bay Area, thank you so much. It's a great tribute to starting these events in the North Bay, and we're really looking forward to our time together this morning. And of course, I always look forward to my time together with speaking with Steve. We actually did our first client presentation we did together in 1992. So I don't usually.
We were both 6.
Right. We were really young, but we've been doing this together for a long time. So Hatfields and McCoys, an interesting story. I know that many of you have probably heard of the Hatfields and McCoys, but how many of you know the story, the real story? See, I didn't know the real story until earlier this week. So I decided to do a little research into it. And, the Hatfields and McCoys is really, a metaphor for a conflict that's escalated out of reason. And we use that a lot. It's the Hatfields and McCoys. We have probably all said it before. But it was interesting for me to find out what it really meant and how that could be applied to what we do every day. So I wanted to tell you a little bit about the story. They were it's the most notorious family feud ever. In fact, the game show Family Feud was named in honor of these two families. The feud actually started in 1863 during the Civil War on the border between West Virginia and Kentucky. And in 1863, Asa McCoy was murdered by a group of local militia, and it turns out that the Hatfields were members of that militia. So that's when the feud started. It kind of simmered underground for about 10 years, and then was reignited over the theft of a pig. And so based on the theft of this pig, this hog, technically, the feud began to fuel. And over about 11 years, 12 members of the family died in this feud. And the feud, or the legal proceedings to convict the people involved in some of those killings actually went to the Supreme Court. And it was an issue around what did they call that when you get transported across state lines?
Mann Act.
Happily named. Aptly named. So here we have a story really about the theft of a pig that ends up in the Supreme Court, right? And that's exactly what we don't want to have happen. So what we're going to talk about today is, fortunately, most of our conflicts don't elevate to the Supreme Court. But they certainly start out small and can escalate very quickly if they're not addressed appropriately. So that's really what we're going to talk about, is how do we look at the conflicts that are around us, whether we're an actual party to them or not. How do we look at those conflicts, and how do we effectively deal with them? All right, so how many of you today have had experience with a conflict in a community association? Neighbor-to-neighbor conflict, recent. Recent, even, okay. So what's some examples of the kind of conflicts that you've been aware of?
Noise.
Fence, noise, satellite dish, parking, smoking, trees.
We have enough examples.
We have enough examples. I knew we were going to have enough examples. So would it be fair to say that, that many of those conflicts could be avoided if, or occurred because there was either a miscommunication, a lack of education, or a misunderstanding? All of the above. All right, so very clearly, communication is the key to assuring that we can navigate conflicts. So that's really where we, as the community association professionals and board members, how many board members do we have here today? All right, good. So this is all just as much your responsibility to know as it is for the community managers, because we're really the leaders. So we're the ones that can create and enhance the communications that happen and hopefully keep the conflicts from escalating. So in a nutshell, clear communication, we've got to act quickly, and we're going to talk a lot about acting quickly and kind of what that looks like today, because that keeps people from getting frustrated and from getting really entrenched in their positions. And then finally, the board as well as the manager needs to understand what all the rights and responsibilities are. And for community managers, one of the mistakes that we make is that we try to protect the board from the conflict. And when we do that, what happens is it goes on too long before it comes to their attention, and the parties are already frustrated. And it really is as much their responsibility to get involved, it's their community, to get involved and try to get resolution around the conflict. So again, the sooner you can bring the board into the situation, and perhaps, you know, perhaps members on that board have really good communication skills, active listening skills, and they can help resolve that dispute sooner rather than later. So it all begins with a clear focus, which isn't always easy to get to when people are frustrated and excited and annoyed with each other and perhaps feeling afraid. So what's important, we have to get really clear on what's at stake, all right? And this is where we have to differentiate between interests and positions. So we're going to introduce you to an example, and we almost got there. We got to parts of it in when I asked you what your experiences were. But an example today is we're going to talk about the owner who has a basketball hoop. He has a basketball hoop in his backyard, and his children play basketball. He has boys, and they play basketball all the time. Day and night, they play basketball. And he lives next door to a woman who tends to be a little noise sensitive. And she also has to leave very early in the morning, so she likes to go to bed about 9 o'clock at night. And she's the one that has brought this issue to the attention of the community manager. And the question is, you know, what do we do about this? And so if you look at those two owners and kind of where they are in the scenario today, they both have positions. She wants the basketball hoop removed, and he wants to keep it. And if we just leave it there, it's going to be really tough to find a place where we can negotiate a solution that works well for both of them. So that's their position. So now we have to find out what their interests are. And we do that by active listening. So active listening allows us to go deeper. It allows us to get more information about what is involved in this scenario. So with a position, people tend to get very stuck and focused. Positions are sort of a divide the pie kind of a solution. They don't build relationships, and they encourage people to withhold information because they're really focused on their position. Interests allow us to enhance the relationship. It's more of a expand the pie kind of a solution, and it really allows us to see what the opportunities are. But we have to get there through active listening. So an example of what the interests of these parties might be is it is in the interest of the owner of the basketball hoop to have his children playing close to home in a safe environment where he can supervise them, but without having to, be sitting there 24 hours a day. But he's trying to provide that safe environment for his kids. The interest of the woman is she really needs to go to bed at 9 o'clock. And she really would prefer not to have too much noise in the hours around bedtime. So if you start to get to the interests, now all of a sudden you have a place to begin the conversation, right? You have a place to start. And active listening is a skill you can develop. We don't all have it naturally because we are generally, when people are talking to us, we're already thinking about what we're going to say, especially when somebody's complaining. Boy, your brain's going 100 miles an hour trying to, lay out what your response is going to be quickly. So active listening requires that we focus our attention completely on the person who we're speaking with, and that we continue to ask clarifying questions so that we can get deeper into the issue. So it might be as you're talking with them, once they stop, you always want to let them just go until they stop naturally. Then they'll be ready to hear you. And then you can ask questions. You can repeat back to them what you heard and say, did I get it right? Is there anything else? And you just keep going until you get to the end. And you may not get every interest in that first communication, but certainly you'll get much farther in that communication than you would if you just sort of took their complaint at face value. So with that, we're going to look at what some of the other players bring to the table. Steve.
Somebody finally figured out how to shut me up. So the Hatfields and the McCoys, they didn't know they were going to end up with the pig at the Supreme Court. And in the same way, these little disputes that we have can metastasize. And we can just watch them go by, and they get worse and worse and worse, unless we are able to step up with some sort of intervention, and as Deborah said, be an active and a good listener, just for starters. And by the way, if you're married, you know what I mean. That is really hard, right? To be a really good listener is really hard. And part of that is because we have misconceptions about what we think are somebody's interests or what their end game is or that. So let's start with some of the board's misconceptions about their rights and their duties and that. So one thing I hear quite a lot is, well, it's a neighbor-to-neighbor dispute. In the hypothetical that we talked about, the basketball hoop, what Deborah did not say is the installation of that hoop was not a violation of the CC&Rs. Okay, let's assume for our story that the architectural control provisions of the documents do not permit the association to regulate an installation in the backyard. And they don't ban the installation of basketball hoops. And yes, we have that old nuisance standard. You can't use your property in a way that unreasonably interferes with the rights of a neighbor. But in a detached single-family home, do you think a judge is going to say you can't have a basketball in your backyard? Particularly when, as Deborah has suggested, part of it is a security concern. I want to be able to see my kids, when they're playing. So even though in that case it's a neighbor-to-neighbor dispute, no violation, and query, does the association have any responsibility? Some of you may know that HUD recently passed a regulation which requires the association to get involved when there may be claims about discrimination based on religion, race, or disability. And so I think the time is coming when we can't take that laissez-faire sort of attitude about it is a neighbor-to-neighbor dispute. And related to that, if there is a claim, if it does escalate badly, sure shooting, the association is going to be joined in that claim on the basis of, hey, why didn't you enforce the CC&Rs, board? Why didn't you enforce the nuisance provision of those CC&Rs? So very easy for us to get tangled up. Interestingly, a colleague of mine practices in Georgia. I was telling Deborah the other day, and they don't put nuisance clauses in their CC&Rs. And I asked him why, and he says, well, you know, in Georgia, we don't think the boards of directors should be the neighborhood policemen. It's sort of an interesting thought. As a lawyer, I grieve over that because we certainly get a lot of questions concerning nuisance, you know. Anyway, so the directors have some of the misconceptions about their rights and remedies. I know you'll giggle at this. Well, we're on the board, we're going to wave our wand, and everybody is going to comply with what we're doing. And that is just a loser big time, especially, again, in our example, the guy has spent money, let alone investing ego in protecting his kids at his home, but he spent money putting in that basketball hoop. And anybody who's been involved in CC&R wars know when someone has spent money, it's really hard to put that toothpaste back in the tube. So let's assume that the board, you know, there's a misconception that the thing is going to work out because, you know, we impose a fine or we censure somebody. I promise you that a $50 fine for a guy that spent, say, 10 grand on new windows or $7,500 on a new deck is not going to be a good motivator. Another assumption directors make is that the CC&Rs are absolutely rigid and always have to be enforced completely. Now, we know the enforcement tools, right? Send a, quote, courtesy letter. We were joking about that.
Yes.
A courtesy letter is the opposite of courtesy, right? It's a nasty gram, right? It looks like this if we were going to paint a picture of it, right? Bring your garbage can in. It's Wednesday, like that. So, you know, I think boards make an assumption that all CC&Rs must always be enforced rigidly. On the other hand, of course, we're always mindful of precedent, and so the two have to be weighed. But there are circumstances where common sense can trump over a rigid enforcement of the CC&Rs. And here's a little secret for the directors in the audience. We managers and lawyers, we spend a lot of energy protecting you from yourselves, right? Don't we? But yeah, we do. And it's in this regard, I think, about how tough are we going to be on enforcing the documents. Another misperception directors have is that owners deliberately violate the documents or don't care, or what's that one where they ask for forgiveness instead of permission, right? Like that. And some people actually don't know. I mean, it's shocking to us because we're all marinated in it, right? But some people actually don't know. They need to ask for permission, you know, architectural approval, something like that. This business about how far will judges go? So why won't the judge understand we're volunteers trying to uphold the CC&Rs that say this? Don't they care about precedent? Answer, not that much. Not really that much. It's shocking, actually. I mean, for me, because we talk about fiduciary duty, we talk about, there's a statute that says when you buy into a common interest development, you know, condo, detached, you accept the CC&Rs. You don't have to sign for them. You don't even have to read them, but they're binding on you. But I promise you, in court, I'll give you a great example. This happens all the time. Somebody makes an architectural change, I don't know, they put in palm trees or a deck in the backyard, and they don't ask for permission. And then we get, you know, we tangle with the owner, and, you know, the board says, well, wait a minute. They didn't ask for permission. Let's file a temporary restraining order, you know, have them take it down. Okay? The judge is not going to issue a temporary restraining order unless somebody is standing at your throat with a knife. It's not going to happen. They have murders, divorces, custody disputes. They don't really care about somebody who put up a deck without permission. Okay? They don't. But secondly, the mediator or an arbitrator or a judge, they're going to blow right by the business of no advanced application. I'm sorry to tell you, they don't care. What they want to know is, had the person applied, would the board have approved it? And if the answer to that is probably yes or should be, we're done. except for maybe we have to pay the other guy's legal fees. So I think judges work very, very hard, and I really do think they care, but they have not, forgive me for saying it this way, they have not drunk the HOA Kool-Aid when it comes to precedent and enforcement. So it's important to pick our battles pretty wisely. Related to that, if we win the case, we get back our legal fees. Okay, here's a little tip about how you interpret attorneys when they talk. Because, you know, we have special ways of talking. And some of them are a little, well, not me, but some of them are kind of snarky, right? Is there any lawyers in the room? Oh, never mind. So, and if we win, we get back our legal fees, right? Oh, yes, the court will issue a award awarding you reasonable legal fees. Okay? So there is a delta between all fees and reasonable fees. And we may think the fees are reasonable because the manager called us 80 times before, you know, and we actually spent the time, right? But to a judge, I had a case once involving a silly case about a shed, and a shed, right? The guy had this beautiful home. It was blue, baby blue masonite siding, like the color of this month's communicator. And he wanted to store his golf clubs, and he built a shed that looked exactly like his house. Baby blue masonite siding with a beautiful shingle roof, like Dumbo, right? Just perfect. Anyway, we went to court over this, and we won, and the fees were $15,000, and the judge awarded $1,500. Yeah, the board blamed me. I told them not to do it, and again, no disrespect, but one of the directors was ex-military. And he felt like the rules are the rules. Well, the rules are mostly the rules, okay? The last thing for director misconceptions is we don't want to spend a lot of money, so let's not have the lawyer look at this. We don't need to tell the lawyer that. And I'll give you an illustration of this, and God bless you managers. When you ask lawyers for a legal opinion, you think you're saving us time by sending us a copy of the provision of the CC&Rs you think is relevant, okay? And we smile and we're grateful for the heads up, but I promise you, what we do is we look at the whole set of CC&Rs. And it doesn't take that long anymore. We do Control F and we search for maintenance or pipes or plumbing or insurance or whatever it is. So save yourself a little time there. So, all right, so those are some of the board's misconceptions, but we've got some others. The lawyers have misconceptions. Everybody wants justice in the first inning. Until what happens? Kara, come on, what happens? When does the board stop wanting justice? When they get the bill, the first bill. Holy crap! Didn't know it was going to cost that much. Right. They never say that on TV. Okay. So the lawyer doesn't know how far the board is willing to go. How important is it that we make this guy repaint his house, the color of his house, or we make him take out the landscaping? You know, if a guy lives in the back, like where Mike Teresi over there is sitting, right? The board doesn't really care. But if he's sitting right at the front of but if he's like where Deborah's sitting at the front of the development, wow, that precedent issue looks a little different, right? So the lawyer needs to know. And by the way, it's on the lawyer to draw this out of the board. This case is going to take a year. There are no guarantees. Everybody remember Casey Anthony? Remember that gal in Florida accused of killing her dog? Did anybody in the planet think she wasn't guilty? No. Did she walk? Yes. So there's no guarantee in trying a case, absolutely none. So, you know, we have to have this discussion. How far is the board willing to go? What's the board's financial commitment? Are they going to stop paying? We hate that. And also, is the board going to be so rigid that pretty soon the attorney fee tail wags the CC&R dispute? That happens so many times. A deal you can do in the 8th inning, if people are smart and are good listeners, like Deborah said, you can do it in the 2nd inning. You just have to back off a little bit and have to get the owner to back off a little bit as well. The lawyer needs to know how flexible is the board on a settlement. Are they willing to say, yeah, you can keep that unapproved deck, but only for 5 years or until you move whichever comes first? Or does it have to come out now? How important is the precedent? If the lawyer says the case isn't that great, are we still willing to fight it to make the principle that we will fight these cases if somebody puts in something without permission? And again, the lawyers need to know the facts and don't hide them. Bad facts, good facts, neutral facts, we don't care. Here's a secret joke about lawyers. We all think that that clients don't tell us the truth all the time. We do. And it's not because someone is trying to mislead us. It's just to the client, it's so obvious the guy violated the documents, right? But we kind of need, the lawyers kind of need to know. So the lawyers for the owners have misconceptions. These are great. Like, why can't the board get back to me in 3 days, right? What do you mean the Open Schmopen Meeting Act? What do you mean 2 days, 4 days notice, right? So also, why do you care about precedent? I have my client. I don't give a hoot about, by the way, they're recording this.
Right.
So for those of you who heard me speak before, you know what I'm talking about.
It's all
right?
cleaned up.
Yeah, that's right. It's all exactly right.
Scrubbed.
It's really hard, too. I'm actually wearing this tie to remind me. That's the only reason. Kept my jacket on for that reason. The lawyer for the owner thinks you exist to solve her problem. And they don't really care a whit about, precedent or any of that business. Likewise, politics. They don't care. Here's another assumption the owner's attorneys make. My guy is the only guy you're coming after. Well, no. Right, Melanie? We've actually had 8 hearings for the same thing in the last 3 years, but no, we're not going to tell you. Can't tell you who. Who? We're going to tell you it was Sally. You know, we're going to do that. How many? You're not picking on anybody else. Yes, actually, we're picking on quite a lot of other people. They think it's just about them. And so we need to get them off of that so they can understand. Another thing is they think they're entitled to everything. Like they want to see every complaint letter about his guy's jumpy gym. No, sorry. Who called my guy out? Well, what's the difference? You know, if we're talking about a noise case, then yeah, we have to say who the complaining people were. But if we're talking about a you built the thing case, we don't need to know who complained. There's the violation, right? So it's different. So transitory violations, maybe we do, but these physical ones, you know, maybe we don't. Also, when the other side, this may be counterintuitive, when the other side's lawyer is inexperienced, it's really bad because they just believe too much in their client, they believe too much in their case, they think they're going to get their lawyer fees at the back end, and they may be wrong, and the board may be locked in. One assumption they do make, actually, sometimes, which is correct, is about insurance, right? Because, as you know, a lot of these kinds of claims we're talking about, like the hypothetical with the, the basketball, there is going to be insurance for it under your directors and officers policies, so long as a claim is timely made, which is when a litigation threat is made, which is long before a lawsuit. You know when I learned this principle? Sessions Rise.
1992.
Yeah, 1992. There was this giant special assessment because this expert, so-called Ken Kosloff, identified structural problems, and it was like a $15,000 special assessment. Don't correct me on the facts.
I won't.
It's inconvenient when you do that. And there was a woman who came to the meeting, and she said, and she was crying, and she said, I can't afford to pay this. I'm a single mom, 2 kids commuting to San Francisco. And if you make me pay, I will sue. And it ended up in the annual meeting minutes, not Deborah, someone else put it in there. And 2 years later, she did sue. And the insurance company, State Farm, asked for copies of all of the records about going back. And they found in the minutes that she stood up and they declined to cover the claim. It took about 6 months of, rah, 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 lawyer talk to get him to do it. So anyway, insurance is definitely a big player here. So that's a little bit of the landscape. So, Deborah, what do you do?
Good question. What do you do? Oh, I think I'm done with that one. So I'm sure most of you in the room already kind of know what do you do. But what's important is to just really think through what can we do to support the resolution of the issue as quickly as possible. As Steve said, even if this is not something where the association is going to enforce for a violation of the governing documents, you have two owners that are in a dispute. And those owners are going to be taking up association time. They're going to be distracting from association business. And they could eventually draw the association and even the management company into their legal dispute for insurance reasons, for other reasons. But it's not going to go away. So the longer it goes on, the worse it is, and the more negative are the outcomes. So what do you need to do? First and foremost, you've got to respond quickly. And this, I don't see anybody in the room that I know that does this, but if I was speaking to a larger, less experienced crowd, here's what I would say. Don't say put it in writing and I'll take it to the board in 60 days. Do not say that. That escalates and inflames a conflict, because then people feel like they're just being dismissed. They just feel like they're being dismissed. You don't care whether this gets resolved. You're just kicking the can down the road, and you're not taking any interest in me. So we don't do that. What we do need to do is respond as quickly as we can by letting that owner, first we've gone through that active listening, so we're understanding what some of the issues are. So now what we need to do is explain to the owner what the process is. And of course, this is much easier if the board has a dispute resolution policy, right? And so if you have that policy, it makes it much easier for the manager to move through the steps and to explain what's going to happen. But then you define the timing of the next step. Now, what you may need to do, because we want to make sure we have all the facts, and you also want to make sure that there's documentation, is you might want to say, during the phone call and as you're going through the process, so that I don't miss anything, and so that I'm sure that all of your concerns are being expressed properly, would you mind sending me a quick email that just summarizes the points and the things that we talked about today so that I have it for my records, as opposed to put it in writing and I'll take it to the board. And that still allows us to maintain the documentation, which can be an important part depending upon how far down the road this particular issue might go. And then we want to encourage and prepare the board to make a quick decision. Oftentimes at board meetings, you're dealing with some of the bigger issues. You're dealing with the insurance contract that needs to be renewed. You're dealing with evaluating bids. You're dealing with a lot of things. And yes, there's these enforcement issues that might be near the end of the agenda. And the reality is they may not all be addressed. And so what you want to do is take these issues where someone is waiting for a response and find a way to get a board decision on the next step as quickly as possible.
May I interject?
Yep.
So the decision here is not the end game. It's not well, we're going to deny that request, or we're going to not pay attention. It's a process point, right?
Right.
How are we going to proceed now that we know there is this problem out there?
Right, right. So it's not a determination. It's what's the board going to do? In some cases, based on all of the information you've gathered and the board looking at the detail, they might say it's important for us to continue to find a way to bring these owners together, because this is going in a direction that might include us. There might be other times when it is appropriate for the board to say, we're not going to intervene at this point. And if that's the choice, and that's the decision, needs to be communicated quickly, but try to offer an alternative. What people are always looking for is, what is my next step? So if the board, with good reason, says this is not an association matter, the two of you have to work it out on your own, here are the names of some mediators in our area that might be helpful to you. Here is a website with information on conflict resolution that might be helpful. You want to be able to try and have some alternative for them, because if it's a dead end, that's also when things start to kind of move in the wrong direction.
What would you say about the board inviting them both to a meeting? Not a hearing.
And acting as a mediator.
Right.
Yeah, I think that's a very effective way of dealing with some of these issues, especially if it's done early on while people are still able to look at each other's interests. If you wait too long, Probably not, but I think it can be a very effective way of resolving.
One of the things we talked about when we were preparing was the possibility that we just sort of stick to the normal roles, especially with a management company that has a series of demand letters, courtesy, send a notice of hearing. And by the way, think of all of those words that we use that conspire against us.
Absolutely.
Hearing, fine, suspension, due
Violation.
process,
Violation.
right? Ixnay on those war words.
Yeah.
And so we have to break, if we can break a little bit out of them. For example, we talked about the board going to the owner and saying,
Knocking on the door.
yeah,
Yeah, knocking on the door and saying, you know, I understand that you, to both of them, but it's just having a conversation with them. And again, all to try and determine what the interests are.
how noisy is it? Would you mind if can I come into your backyard next week, you know, when their kids are probably playing so I can hear that ball bouncing?
Right, right. Or asking the other neighbor, would you mind if I came over at 8:30 and hear what you hear and understand the magnitude of the situation?
Right.
Yeah, all good ideas. And then, you know, finally, I'm not going to skip over recommend lawyers that solve problems. I would be in trouble. So we want to recommend lawyers that solve problems, not lawyers that escalate disputes and get people positioned. So we want to look for lawyers who, again, will not just take the hard and fast. This is what the CC&R say. This is what we're doing. We're done. We want lawyers that will say, you know, there's a business decision to be made here, and let's talk about what the alternatives are, and leading the board into making a good business decision. And last but not least, you know, develop conflict resolution skills. And that's really, I mean, I think in today's world, I certainly don't like conflict. I think most of us would agree that we don't enjoy conflict, but it can be worked through if you develop the skills to do that. And one fun way, and part of that developing the skills is understanding how do you personally deal with conflict. And there are specific styles, just like there are communication styles, for how you deal with conflict. And there's an instrument that you can take. It's free, and it's it's the Thomas Kilman Conflict Instrument. And Kilman is K-I-L-L-M-A-N, Thomas Kilman Conflict Instrument. And if you Google that, you can go to their website, and you can take an instrument that tells you how you handle conflict. You know, are you collaborative? Do you get defensive? It can be really helpful. So I would encourage you to take a look at that. We have mostly gone through these points, so I'm going to go through them relatively quickly so that we can kind of wrap it up and give you a few minutes for questions. So when the owner calls, you know, have a prompt and clear and candid discussion with them about the process when you're hearing that complaint. And you know, we haven't talked about email. And what I do have to say about email that I can actually get to today is, you know, it's not always going to be the best communication when somebody writes you with a complaint. Because number one, you know, the communication is not happening in real time. It makes it much harder to get to interest when you're trying to communicate via email. So when you get that complaint, I encourage you to you know, find the appropriate time quickly, you know, to have a phone conversation with that person, because it makes it much easier to identify really what the issues are. Again, continue to do identify next steps and timelines. Managing expectations during this process is the most important. And then if you do set an expectation, we want to make sure that we follow through. So some of the most difficult and angry owners I have ever spoken to were those that were promised that the board would take an action at the meeting, and it didn't happen. And the next day, we had to call and say, no, this did not get addressed by the board last night, and it won't be addressed for another 30 days. That is just one way to take a conflict and move it directly into positions and possibly even, you know, hiring lawyers. And you know, once people start spending money, so they've spent money already on their basketball hoop, but if the woman who's not getting sleep, once she starts spending money on a lawyer, it's going to be much harder to reach an agreement with her. And then no matter how how much you empathize, no matter how you could relate to how much you would be bothered by a situation. Do the best you can to not promise, make any promises about how the board is going to respond, or commit to a specific decision, because that really is something that needs to happen at the entire board level. Even if you're the board member who goes over to have a personal conversation with either party, really don't commit. You're there on a fact-finding mission. You're there to experience what they're experiencing, but no commitment on decisions. All right, so we're going to pull this all together and give you a few minutes for questions. So in a nutshell, given everything that you've heard today, what you want to do is first and foremost, identify the interest. Get off position as quickly as you possibly can. And then take very serious action. Again, Steve mentioned this. For all of us, we see violations, we talk about it, it's our life, we deal with it all the time. For the one owner that's experiencing it today, it may be the most important, difficult issue they're experiencing. So we have to try and take it as seriously as they're taking it, right? And then define the information and resources that are available to make the decision, or that you need to make the decision. And that goes for board members and managers. What do you need to be able to make a decision about the next step in this issue? Foster communication, the communication tree. So there are ways to get to a decision about a process without having to have a board meeting. We just have to know how to do it, right? And we're all good, I think, at figuring out how do you have that communication tree so that all the board members are in the loop, but you could still take an action and move a piece of enforcement forward, or decide whether to proceed or not proceed. Just make sure that you're doing it appropriately, and if you do have to have a special meeting, make sure that you're complying with all the notice provisions so that it's a legal meeting. And then again, get those reliable problem-solving professionals on board, whether they are good lawyers or mediators. We are fortunate in this area to be somewhere where there are a lot of qualified mediators and some community mediation resources. So, find those resources, have them available, and then those conflict resolution skills will really pay off. So, do you want to come up for questions?
I don't have any questions, thank you. No, you were great.
Oh, I'm sure there's going to be questions.
I think it's good to, I guess the last word I'd say is, especially for managers, let's not overinvest in the answer too quickly. You don't have to get defensive when somebody has a problem. You don't have to make it about, well, it's your fault or any of that. It's part of the act of listening and being patient. And getting too quickly to have an attitude is just a real recipe for having the whole dispute kind of get out of control. What's that? Yeah, exactly right, Brandon. Yeah. And remember, from the owner's point of view, it is the resources of the board with all their money, the management company with their fancy website, and people all around, and it's just the owner. And so it's very easy for polarity to occur in a way that is not good unless we really are showing and meaning to have respect for the owners, right. Whichever owner we're talking about, whichever concerns there are. And again, I do want to emphasize this business of breaking out of the mold. You're busy. Your board package is yay thick. You're getting it 5 days before the meeting. You have in your mind really big stuff. Reserve study, financing, big special assessment, CC&Rs, mold. But to this person, their basketball issue is a deal. And so it's hard to just send him a demand letter, send him the fine policy. He probably doesn't have the rules. And that is contrary to the things that we're saying.
Yeah, exactly.
So, oh, good.
This is just for your information. In 2003, the Hatfields and McCoys signed a peace treaty.
Who are you?
I'm not
Simply diplomat or something?
I read stuff.
Okay.
I know how to read.
Okay.
Yes, 140 years after the thing. I think it might have been a stunt for the annual Hatfield McCoys. Stunt for the annual Hatfield McCoys festival.
I just have to ask you,
right.
did they have a lawyer help solve that problem, or did they figured it out on their
That's why it
own?
took 140 years.
Good answer.
But my real question is, look, I mean, sometimes you have a homeowner who is ignorant, arrogant, narcissistic, sociopathic, and has a great sense of entitlement, and really you can't get through to them. And what do you do with that extremely difficult person?
Well, this sounds like something Deborah would know the answer to. But I do think we have to at least follow the process.
Right.
Because
Right.
if it's that bad, it's going to end up in a place where somebody who has no skin in the game is going to be evaluating everybody's conduct. Deborah, do you have
Right.
a
So the
thought?
way that I would answer that, did everybody hear the question? Okay. The way that I would answer that is you have to take their issues one at a time. And I used to and still recommend that when information is coming to the manager or the board, don't judge the message by the messenger. Even though it's the same messenger over and over and over again, each question, each issue really needs to be evaluated independently, because it may turn out that this one is real, as opposed to the 10 or 12 before. So you just have to continue to follow the process. And of course, you educate as much as you can along the way. And if it doesn't stop and the issues are not valid, then at some point you have to hire a lawyer that's good at solving problems and have them write a letter and try to work it that way.
Deborah,
yeah.
this from the back of the room. One of the struggles that we find is it's a big enough struggle to get the board to agree to bring in the attorney. And then once they bring in the attorney, many times we find the board gets so stuck that it's, blood at all costs.
Right.
And so if you have any helpful suggestions on how to encourage the board, and we find it with new board members, and this is going to sound really bad, non-business people. When
Right.
we have business people on the board that are used to negotiating and used to dealing in their own business with attorneys and contracts and just dealing with people, sometimes it's a little easier, but sometimes we get homeowners on the board that become so solid in their position that, first of all, it's a struggle to get them to bring in the attorney, and then once they do, they're going to get their money's worth from that attorney, and they just have a really difficult time getting to agreeing to a compromise because they view that they've weakened their position and that their attorney is weak because they feel the attorney won't fight for them and is just trying to get them to the center. So
Right.
words to help move that forward?
Well, I think that what can help move that forward is to focus on the conflict resolution skills, and to focus on training around conflict resolution. So there's a couple of different resources. There's the Thomas Kilman model that I explained. They have other resources there, but there's also something called the circle of conflict that talks about how conflict is created, and also the things that you can do around those specific types of conflict. And I find that if you just have that education, then maybe the person who's stuck will see themselves and perhaps be willing to move something forward. But you've got to hire professionals who will help solve the problem and help the board see what they need to do next. So that's about as good as I can get, I think, with that one.
So for those of you who are not high up in your company, one approach may be to bring in a supervisor, a vice president, something like that, who doesn't know this client particularly. This problem, could really become a bad one. I'd like to get my boss, Kara, to come to a meeting to offer an objective point of view.
Right.
The trick is you don't want to lose the client, right?
Right.
But or maybe you do. And in terms of the lawyering, you got to give that lawyer a heads up. You have to tell her, this board is pretty locked in for whatever reasons there are. They've dealt with this problem. They dealt with this person. The worst one, the director lives next door. Whatever it is.
Yeah.
And give the lawyer a cue on, don't get ahead of yourself on this. The best issues, this issue may not be a best one for upping the ante quite a lot. Another alternative the lawyer might propose is, Okay, if that's it, let's go to binding arbitration right away. Binding arbitration is one and done. No big lawsuits. Takes a month or 2 or 3. You win, you lose, and guess what? The sun comes up the next day. Either way. Yeah. So it's not a perfect answer, but rip off the Band-Aid. Maybe that's an approach as well. Okay.
All right, it looks like we're done because Kelvin and Emily are on their way up, so thank you very much.
Did we end up on time? The flight landed perfectly.